Welcome to the Silverbridge CPA's Summer Speaker Series. We hope you enjoy this message.
I'm Silverbridge CPA's firm administrator, and thank you for joining us for our third and final Summer Speaker Series of 2024. We are very fortunate to have Mignella of Jones Williams Fuhrman Gourley, PA, presenting today. Megan will discuss the various options for testamentary planning, which will include a review of important documents to have in effect prior to your death, i.e. powers of attorney, and a comparison of wills and trusts. She will also review the basics of administering an estate after death and alternative planning options to keep in mind when making these decisions. I'll introduce her shortly, but just a few items to go over first. If you haven't already done so, please be sure to mute yourself. You can do that by clicking the microphone in the upper right corner of your screen. This presentation is being recorded, so if you don't want to be in it, please just, turn your camera off, which is also up in the right corner of your screen. You should see a little camera image. And then you are welcome to type your questions as you have them into the chat feature. And then at the end of the presentation, we'll go back through and read them, and Megan can answer them. And then if we have any time after that, you can always unmute yourself, just ask at that point. So we'll definitely save some time for questions, okay? With that said, I will go ahead and introduce our speaker. Megan Mignella is a shareholder with Jones Williams Fuhrman Gourley, PA, and assists clients with estate planning and administration, business and property matters, as well as related disputes and litigation. She does not hesitate to advocate for her clients when appropriate, but will also communicate openly about benefits of negotiation and the practical implications of court involvement. Megan is a third-generation lawyer, born and raised in Phoenix, Arizona. When she's not in the office, Megan enjoys spending time with her family, usually chasing after her kids. All right, Megan, I will go ahead and turn it over to you.
Awesome. Thanks so much, Brittany. Hi, everyone. Good morning. Excited to be here. Thanks for having me. As Brittany said, I'm an attorney at Jones Williams. I've been practicing over 10 years now. I started my practice in Spokane, Washington, and have been in the Treasure Valley area for the last 7 years. So thanks for having me. Looking forward to talking about some really fun stuff today. I try not to make it too morbid because it's always fun when you walk into my office and we get to sit down and talk about, death and what happens after you're gone. But it's really important to be prepared. And it's important to have those conversations so we can be prepared in the event something happens, because at some point it's going to happen to all of us. So like Brittany said, please hold your questions to the end. Feel free to use the chat function. If there's a question that you're not necessarily comfortable asking in this setting, my email is at the end of this presentation, and you're welcome to reach out to me directly, and I'll do my best to answer your questions. So with that, let me get this. There we go. So lawyers are the best. We have to do our fun disclaimer first. Generally, I'm just giving you some information about estate planning and probates and wills and trusts. It's not specific legal advice today to you or your situation. Unfortunately, today I'm not your attorney, so I'm just disseminating some information for you to think about and digest. But a lot of this information that I'm going to give you today is what I typically cover in my initial meetings with folks who come in for estate planning. So good to keep in mind for your own situations. And like I said, if you've got questions, feel free to ask me afterwards or consult your own counsel. So kind of an agenda for presentation today. We'll start off with just generally what is an estate plan, and then we'll talk about intestacy, which is what happens if you don't have an estate plan in place in the state of Idaho. Then we'll jump into wills and trusts and kind of talk about the differences between those two, and then also talk about powers of attorney and those documents, which are just as important, I think, as your will or trust, or neither. So to start off, what is an estate plan? An estate plan is something that's documented that provides some structure for how your assets are going to be distributed after you die. It can include a wide range of items for planning purposes, financial, retirement. If you have a business, it can help with succession of your business. It can address disability, medical issues, really overall what you want your legacy to be, and any gift planning that we we need to do. If you want to plan for charities or distribution to charities, that's a way that your estate plan can help with that as well. I'm of the perspective that most everyone needs some type of estate plan. Even if you think you don't have enough or your family will be okay and they'll figure it out, there's always something that we can do to help you be better prepared. And really, it's to help your family members and the next generation be better prepared from my perspective. A lot of my practice recently, in the recent years, I handle a lot of trust and estate litigation issues, which is folks fighting over what an estate plan says, or they think they should have gotten something that mom or dad didn't give them. It's a really tough area to litigate because it's really emotional, but a well thought out estate plan and some structure we can do our best to prevent that from happening after someone passes away. So there's never any guarantee that people aren't going to fight over things, but like I said, I think everyone needs something in writing so that we try to prevent those fights from happening to the extent that we can. And so typically documents that are in an estate plan, you see a will or a trust, which is your kind of your meat and potatoes. That's your substantive distribution document. And then you have powers of attorney, and I'll talk about those a little bit later. But your powers of attorney are in effect while you are living, and then your will or trust comes into effect usually after you die. So do I need to update my estate plan? Always a good question to ask. If you've got an estate plan right now, always the first thing I look at is when did you sign it? If it was signed back in, 1995, things may have changed drastically in the past. Math is not my strong suit, 30 years, right? And so good to look at that because you never know. And the law changes too. So it's always good to do kind of a health check. I like to say every few years or upon any big life changes, right? So for example, you've had children, you've had grandchildren, there's been deaths in your family or divorce or disability. People's needs have changed, right? And maybe we need to plan for that, especially if you move to a different state or a different country. I strongly recommend that you take a look at your estate plan to make sure that it still works for wherever you move to. Same thing if you've come into Idaho. It's good that you've got something in place, but it may not be aligned with Idaho law the best way that it can be. So we always like to look at that upon a move. If you have new assets, like if you've won the lottery, great, good for you. I'm totally jealous, but that's something, fluctuations in wealth is really important to take a look at your estate plan to make sure that we're using all of the tools that we can to the best advantage, considering the circumstances. And then, of course, if you want to change your estate plan, right? If you want to change how things are distributed, maybe instead you think that maybe one of your kids needs a little bit more help than the other one's really successful, and you want to make some adjustments to how the distribution is going between the two of them. That's a good time to update your estate plan. So really, like I say, every few years or upon big, life changes, good time to do a health check on that. And, the other thing too is you want to make sure that all of your assets align with your estate plan, right? You don't want to have a whole, set of accounts or assets or property over here that haven't been accounted for in whatever your estate plan is. And there's nothing wrong with do-it-yourself estate plans. You can actually buy them on Amazon and at Walmart. There's packets and stuff now for your estate plan, but they can result in some confusion after you die. They can also have some mistakes made that then either nullify the estate plan or bring into question its validity. And so from my perspective, I do think it's better to have something than nothing, but I think that if you're going to do a DIY, be very careful about how you do it because even things like Rocket Lawyer are great tools to have, but they don't always take into account everything that they need to, right? Because it's all about asking the right questions too, and sometimes you can't do that with an internet or with a internet service or a packet. So got to have some funny lawyer jokes in there. So the first kind of substantive section that we'll talk about is the Intestate Act, and and this is what happens if you die without any estate planning documents in the state of Idaho. So if you don't have your directives laid out, Idaho has a default set of laws called the Intestate Act that provides for a distribution of your assets. So a lot of folks I talk to just think that if you don't have a will or a trust, the state of Idaho will take your assets. That's not the case. That's a whole other process that doesn't happen for a very, very long time. But Idaho and most states have an Intestate Act, which comes in and dictates, again, the distribution of your assets if you don't have those directives laid out beforehand. So pretty much Idaho law decides what your distribution is going to be if you don't. So like I said, it's a default. It's a fairly standard distribution. It's kind of what you would anticipate. It provides for the spouse and kids. But importantly, intestacy does not provide for a lot of blended family relationships. So it only provides for children and individuals who have a legal relationship, and oftentimes that's a biological relationship. And we can't change the definition of that without changing Idaho law. So something to keep in mind. So again, especially important if you do have a blended family and you don't want the standard distribution. Maybe you've got folks you want to include who aren't your legal relations to have some estate planning documents in place. Importantly, the intestacy distribution scheme can't be changed at all. So if you die without a will, or if your will is not probated in a timely manner, distribution is going to be by intestacy, and that's it. We can't really change that. So not a lot of wiggle room there from my perspective. Things like 401k accounts, retirement assets, life insurance policy, those are what we call non-probate assets because they have a beneficiary designation on them. And so those pass outside of your will or your estate anyways, and we'll talk a little bit about that later. So when we go through intestacy, I think it's important to kind of give you some examples of how that default distribution will go, just so that you're aware. Idaho is a community property state. And so anything that you essentially have during your marriage is typically considered or presumed to be community property. The only things that most often are not community property are, which is called separate property, are items that you owned prior to marriage and items that you received by gift or inheritance during marriage. That can change depending on the circumstances. Determining community and separate property is actually a pretty detailed analysis, and there's a lot that goes into it. It's not always black and white. But generally, that's kind of the presumption that we work under because Idaho is a community property state. So in Idaho, when you create your will, or if your estate goes by intestacy, a spouse can give or devise 100% of whatever their separate property is, and then 50% of their community property. And the other spouse owns the other 50% of their community property because it's a shared asset. So if you don't have any estate planning documents, and you die with a spouse who survives you, the spouse will receive, the deceased spouse, 1/2 of community property. So that 50% of the decedent spouse will go directly to the surviving spouse, and that's only for community property. Now, for separate property, if there's no surviving children or parents of the deceased spouse, then the surviving spouse receives all of the decedent's separate property. If there are surviving children or parents, then the spouse receives only 1/2 of the separate property. And I'll do an example in a few minutes because this is kind of it's a difficult kind of analysis to follow. But if you don't have estate planning documents, there does have to be an analysis of what is community property and what is separate property. And then that determines what the surviving spouse will get. So we'll look at an example, like I said, in a couple of minutes. So if there are surviving children, then they receive any share of the decedent's separate property that the spouse doesn't get, and they'll receive it in equal shares. And again, we talked about intestacy being a default distribution, right? So we've got a couple of layers of intestacy. You have the spouse and the children level. And then if there are no children, then there's grandchildren who come into play. And so if there's a child who predeceased the decedent spouse, then that child's share will be split equally by their children. And so we call that they take by right of representation. And so here, let's go for the example, because I think that kind of helps a lot. So mom and dad are married. They have 3 children. Dad dies without a will. So the state of Idaho has the intestacy statutes that provide that dad's estate will pass as follows. So since mom is still living, mom receives 1/2 share of the community property that she shared with dad. So mom already owns her 1/2 share of community property, and she will receive dad's 1/2 share of community property. And since there are children, mom only receives half of dad's separate property, and the other half of dad's separate property will go to the 3 kids. So essentially, the 3 kids are sharing in 1/2 of dad's separate property. And there isn't always separate property. If you've got folks who've been married for a long, long time, there may not be any separate property at that point. And again, that's just because Idaho is a community property state. And so the presumption is everything is community property. The kids in this case, if they think that there's something that's separate property and not community, it would be their burden to come forward and show why that asset is separate property and not community property. So a little bit confusing. And the default does, like I said, doesn't stop with the kids or the grandkids. So if there's no surviving spouse, then the children come into play. If there's no children, then the grandchildren and great-grandchildren are provided for by intestacy. If there's none of those individuals, then intestacy provides for parents of the decedent, which there often aren't any parents. So if there are no parents, then it's to the descendants of the parents, which would be the decedent's siblings, their nieces and nephews, their cousins. It's essentially like a hierarchy that the distribution would go to if there's a line of your family tree with no descendants in it. And if there's no parents or descendants of parents, then it goes to the grandparents. So it goes all the way through the grandparents' family tree too. Oftentimes we don't ever get that far. It's in a very rare circumstance that there's no spouse or children or grandchildren. But again, that's why this is a default in Idaho law. And you have in your estate plan someone who's called a personal representative. They are also referred to as an executor of your estate. This is the person who comes in, administers your estate, inventories all of your assets, pays your final expenses, and ultimately makes the distributions. If you don't nominate this person in an estate plan, Idaho statute determines who's got priority to serve as personal representative. Another problem with this is, the spouse has priority, but then under that, children have equal priority most of the time. So you can see siblings saying, well, no, I want to do it. No, I want to do it. That can lead to conflict too. So again, another reason why I think it's really important to have an estate plan written down so that you are the one who's making those decisions and you're not leaving it to your family members to pretty much roll the dice and see what happens. And so I've got a case right now where there's siblings fighting over who wants to be personal representative of their parents' estate because their parents kind of sort of wrote something down, but it wasn't enough. And so it's left it open. And so you see families really struggle with that sometimes. So again, another reason to have things written down. And so I think with that, we can talk about wills, which is one of the first ways that you can document your estate plan. And so if you have a will and it's a valid will, the Intestacy Act does not come into play. So your estate will be distributed pursuant to your will. So like I said, so long as there's certain formalities that are met and so long as the probate process is followed appropriately. And so generally speaking, a will is a document with a set of instructions for the distribution of your property, and it takes effect only upon your death. So you create a will and it doesn't really do anything until you die. And so, you can kind of set it and forget it, but for checking your estate plan every few years to make sure it's still up to date and meets with your intent. But that's kind of why wills tend to cost less to prepare than a trust. And they're just kind of known as a simpler document, right? Because you just create it and then you don't have to worry about it because you're not around to worry about it. But it doesn't come into effect until you die. Sometimes they are easier to change because all you have to do is either create a new will or what's called a codicil, and that's like an amendment to your will. You get to choose who acts as your personal representative, which I think is really, really important. And you actually choose not only your first choice, but I'm of the practice where I like to have at least an alternate and a second alternate, right? Because worst case scenario is everyone you have chosen or the first two people you've chosen can't do it or have also passed away or for some reason are not qualified to act, then you've got someone else as nominated to act as your personal representative. And so I like to look at estate planning in general as a plan A, a plan B, and a plan C, right? If we're going to go through the process of creating an estate plan for you and you think about all of the decisions that you have to make and your assets and your legacy, then I'd say let's just do it all the way, right? So you've got a plan A. This is everything goes the way that we think it's going to go. Plan B kind of plans for some contingencies, right? Where we think things may have shifted, but we can't really anticipate that. And then you've got plan C, which is awful, but sometimes I refer to it as the plane crash plan, right? Everyone that you have nominated as your personal representative or who you want to receive under your estate plan is all on a plane and the plane goes down, right? You want to have a plan C contingency in there as well. So that's the positives about wills. You get to make all of those choices. And also in a will, you can name, if you've got minor children, you can name a guardian for your minor children. And that's an individual who takes care of the physical well-being of your minor children in the event that you can't. And you can also name a conservator, and that's the person who handles your children's finances when they're minors. But sometimes that can be a trustee, so we'll talk about that in a minute as well. But I think that's a really important consideration, especially if you've got young kids, to have that laid out so that there isn't a lot of question about who will take care of your kids. So to execute a will, there's certain formalities that have to be followed. And I'd like to say I know why, but I don't know why. I think it's important to have some of these in place, but some of them are just, wills are long-standing legal documents, and this is kind of how it's always been. So you have to be over the age of 18 or an emancipated minor to sign off on a will, like any legal document. You have to be of sound mind, of course. A will has to be in writing, and it has to be signed by the person making the will. It also has to be signed by two witnesses. I think that's probably the most important piece of a will, is that it needs to be witnessed, because in the event someone down the road has some questions about the will or thinks that it was created under suspicious circumstances, or that someone held someone's hand to sign the will, those two witnesses are the people who you can call and say, what happened when you signed this will? Was the person of sound mind? Were they able to create the will? And so I think out of all of those, that's probably the most important one. They're all important, but your witnesses give you, it legitimizes your will to an extent. My preference is, when I have folks create wills, is that you sign them in my office and we've got neutral witnesses here, right? We're not going to be receiving anything under your estate plan. And so we don't have a stake in signing the will, right? We don't have any sort of advantage that we can give. So while it's not always required, I think it lends a lot of credibility to have neutral witnesses witness a will. You can also, in Idaho, have a holographic will. And a holographic will is a handwritten will, and the signature and material terms of the will are in the testator's handwriting. Obviously, I put there I do not recommend because it can be one of those things that is almost a guarantee of some sort of litigation or conflict after someone dies. It creates a lot of questions. You may not be able to read the person's handwriting. The signature may look different. There's always a question, I think, of what material terms means, right? Can you write a piece of it and then put a sticky note on another piece of it and then sign it? I don't know. It's an area that a lot of my litigation cases deal with holographic wills because they are so open to interpretation and there's not a black or white answer. One of the other attorneys in my office has had a long litigation case with a holographic will where no one could read the handwriting. So no one knew what it said, but they all argued what they thought it said. And it just was a mess. So I think that if you're in a pinch and you don't have an estate plan in place, that you can do a holographic will, right? Or create a holographic will on a very temporary basis. You know, look, I'm going into surgery and I want to make sure my spouse can have what they need, right? So you quickly write, I want my spouse to have everything that I own, and you sign and date it. I wouldn't, like I said, I wouldn't recommend that for a long-term solution, but it can get you by in a pinch. And so again, the holographic will can create a lot of outstanding questions. There's something that might be missing when someone creates it themselves, right? Like we talked about the DIY too. So again, do not recommend, but if you need to do it, you need to do it. Wills can include trusts. So just because you aren't creating a trust document in and of itself doesn't mean you can't utilize the tools that a trust can give you. So oftentimes we see this where you know, mom and dad have minor children and they don't want their minor children to receive, you know, an influx of funds when they're 18 or 19 or 16 or 17, right? And so we create what's called a contingent trust, essentially, that will be funded only in the event of your death. And so it's a really great tool to use because, again, we don't have to really do anything with that right now other than create the will and the trust. The trust doesn't even come into play until you die, right? So, and there's terms in that contingent trust that dictate how it's administered. So, and there's certain ages that you can lay out and rules for how you want your children to receive those funds. So like I said, great option for younger children. So we don't want minors or young adults to receive a large sum of funds, like essentially a blank check without restrictions or limitations. You know, we don't, I talk with a lot of clients about kids who are in college or kind of just starting out their adult life, right? Trust can be appropriate for them too, because they may not use the funds the way that you want them to use the funds, right? At that point in time in their lives. Or they might, maybe, you know, you've got kids who know how to do it, but they have to be over the age of 18 to receive the inheritance. And so the funds will be held in a trust for the benefit of the children until they reach a certain age or until a certain life event happens. And you can set it up so that this contingent trust provides distribution for your kids for almost anything. We call it a MESH standard. It's just a general ascertainable standard, which stands for maintenance, education, support, and health. And that pretty much covers almost all of the expenses that your kids are going to have. So it includes living expenses, education, healthcare, medical, soccer club, you know, entrance fees, travel for the soccer club, all of that, which is great because you don't know exactly what your kids are going to need after you're gone, right? A lot of my contingent trusts also include a provision where your guardian, right, can live in the home that you guys have been living in, or the children's trust can provide funds to the guardian to add on to their home so that the kids can live there with them, right? So essentially, these types of trusts are set up really to give a lot of flexibility to make sure that your minor children or young children have the care that they need. And I think a big one is education as well. So, you know, we can lay out distributions for college, trade schools, vocational, you know, apprentice programs. It's kind of limitless options, which is great, so that we can really cater it to what your family's needs are. The other thing with these trusts is we can provide for your children, if they want to start a business, we can provide funds for that, or lay out, some requirements that they have to meet and present to the trustee as to why they want to start this business, right? And the trustee can say, okay, well, here's some concerns that I have. Have you talked with an advisor or CPA, things along those lines, right? Before funds are distributed. They can also provide, like I talked about with the guardian, but you can also provide funds for real property purchases as well. So it's a really great tool. And just because you have a will doesn't mean you can't use a trust. And so, like I said, you don't want to give $5 million to a teenager. Not ideal. And so after you die, we've talked about wills, kind of you create them and then they don't come into effect until after you die, right? In the state of Idaho, wills require the process of probate after death. So if you own over $100,000 or if you own real property at death, then a probate's required. I will tell you, I think it's a great advantage to have the probate process here in Idaho, because the court not only oversees the administration of the estate, but it's a process where your heirs receive their funds ultimately at the end of the day, knowing that there isn't some creditor out there who's going to come back and get those funds. And the nice thing, I think, in Idaho, and I've also practiced in Washington, is the probate process is pretty black and white. The rules are what they are. And, I know the slide said that the court oversees administration, but really the court's not involved in the administration of the estate. Probates are, I like to look at them kind of in three parts. After death, they're kind of front loaded, right? Because you kind of got to go see the attorney and get the stuff into the court and get appointed as personal representative. But then there's a period of time where the personal representative is just doing their job and the attorney doesn't always need to be involved, right? So there's a little bit of work in the middle and then they're kind of backloaded at the end to get everything wrapped up. So from my perspective, it's a good process for folks to take advantage of. And so you have to probate a will within 3 years of someone's death. Otherwise, even if they have a will, the will isn't valid. And then that's when those default intestacy laws will come in to play, and it will overrule whatever distribution you have in the will. As part of the probate process, the will is filed with the court. So generally, it's not a confidential process because your will is lodged with the court. We send the original will down to the courthouse and they keep it at the courthouse. So, but I will say, I don't think a lot of folks go searching the court records to see what everyone's will says, but technically it's not a confidential process after death. We talked a little bit, or I mentioned this a little bit earlier. There's a category of assets called non-probate assets. And again, typically these are assets that pass outside of a probate estate. So your will doesn't have any say over these types of assets. But as part of the estate planning process, we always go through and kind of do a health check on these assets too, because you want to make sure that if you've got a life insurance policy, it matches with what you have in your estate plan, right? If your will says you want everything to go to your kids, but your life insurance policy says you want it to go to your girlfriend from college, that doesn't match up, right? And so there's going to be some questions there. So as part of the estate planning process, we do a check on these ones too, right? So we look at retirement accounts, we look at life insurance policies, we look at any assets that are owned with rights of survivorship. That includes things like bank accounts. That's a very sticky area of the law right now. And so you have to show that if you are the survivor on that account, the survivorship owner, that the other party intended for you to receive those funds. And so there's a few ways we can address that. But again, other examples are pensions and just any other accounts with the beneficiary designation. Sometimes we see, annuities or CDs or just kind of other investment accounts. And so, again, really important that all of that is consistent with your will or your trust, right? Depending on what you decide to do. And so with that, I will turn to revocable trusts. I like to look at these essentially as a personal corporation. It holds most of your assets. You don't function as an individual anymore. You function out of your trust. And so you have to create the trust, you fund the trust, and you maintain the trust during your lifetime. And so as long as the trust is maintained properly and funded properly, you don't have to go through the probate process. I will say this is not the legal term, but if you don't use it, you lose it, right? It doesn't make a lot of sense to set up a trust and then not fund the trust, not use the trust, things like that. I think a good example of how a trust actually works is you create the trust. It's a little bit more complicated than a will. There's other documents that are involved in that. And then you fund the trust, and you do that by transferring your assets to the trust. The best example of that, I think, is real property. When you buy a piece of property, maybe you're married and you take title as husband and wife. If you create a trust, in order to fund that trust with the real property, you have to retitle the property in the name of the trust. So we create a deed, and then the deed itself is recorded, and that transfers the real property to the trust. But as an example, if you set up this trust, you fund it, you put your house, your residence in it, and everything's going great. But then down the road, you buy, let's just say you buy a cabin up in McCall or something like that, and you take title to the cabin as husband and wife. That property is not automatically in the trust just because you have the trust. You have to deed that property over to the trust. And if you don't, then you're going to have to go through a probate because you've got property that didn't make it over to the trust. And so that's kind of I think the best way to look at how a trust functions, is you have to use it. And so just like a will, you can create trusts for your children, and create things for their benefit, and hold those funds with certain limitations, right? And the parties to a trust are three individuals. You have the trustor, which is the person who funds the trust, right? You have the trustee, which is the fiduciary who oversees the administration of the trust. And then you have the beneficiary, which is the person who receives the benefits from the trust. All of those individuals can be you during your lifetime. And so again, trustee kind of is like a personal representative, but they are functioning in the trust. And so I look at those as a plan A, plan B, plan C as well. The big question is, do I need a trust? I think this is something that I talk a lot with clients about right now because there's kind of this idea that trusts are these magical unicorns and they will solve all of my problems and no one can ever get to trust funds and no one will ever know about it. And it's pretty much like a golden ticket. And I hate to break it to you, but that's not always the case. It really depends on your particular circumstances, whether or not a trust makes sense. They are complicated. You do have to make changes to how you function kind of on paper, if you create a trust. But, when folks have property out of state, I think that's a really good situation for a trust because it kind of serves as an umbrella corporation for all of those properties. If you have serious privacy concerns, that's something that trust can help with because, again, they're not lodged with the court the way that a will is with a probate. You've got continuity of asset management, right? As long as you fund the trust. But you still need a will, even if you have a trust, because it functions as a safety net in the event there is that cabin in McCall that didn't make it to the trust. And you need the will to probate the cabin in McCall to get it over to the trust so it can be held by the trust and ultimately distributed. And so generally trusts cost more and are more complicated than wills. And again, depending on the circumstances, they can be difficult to change. But again, you can always make an amendment to them as well. So after someone dies, if you have a trust, it can be a quicker administration. It just depends on the terms of the trust, and it really just depends on the circumstances. with your assets at the time that you die, right? And kind of with the context of how family things are going at that time. Trusts can be contested in the exact same ways that wills can. So again, trusts aren't those magical unicorns that prevent anyone from coming forward and saying, oh, I disagree with this and mom didn't mean it that way. And that's actually not mom's signature. You see those same types of disputes with trusts as you do with wills. But again, generally speaking, if it's used the way that it's supposed to, it will be private and probate can be avoided. There's not a mandate for the court to be involved, but typically you have to register a trust with the court, again, depending on circumstances. And I think the biggest takeaway that I would like you to know today is just because you have a trust doesn't guarantee that there's not going to be a probate. And so I've kind of got a little overview of wills versus trusts, right? You can provide for minor children in both. You can address blended families in both. Disagreements are kind of addressed in the same way. They both protect from creditors because you can create a certain trust in both a will and a trust to do that. Again, there's no guarantee that trusts will avoid probate, no guarantee that it's going to be quicker, and wills are a little bit simpler and less cost upfront, and whereas trusts take a little bit more. And I think my perspective on estate plans generally is not all estate plans need to have trusts or need to be overly complicated. Again, the misconception is that everyone needs a trust and the trust will fix everything. That's not always the case. So I think it's really important to know what your goals are and have that discussion with an attorney when you create your estate plan. Some other considerations, we've talked a lot about minor children. They can be provided for in wills or trusts. So can pets. You can provide for your furry friends. If you've got people who are receiving funds from your estate plan who have supplemental needs and who may be receiving benefits from the state for medical care, that's something that we can take into account as well. And of course, charitable giving, right? If there's organizations that are close to your heart, that's something that I see a lot of folks do, that in the event, everyone is on the plane who I love and the plane goes down, then here's the charity of my choice to receive everything versus some distant cousin or niece and nephew. And another consideration to think about are limited liability companies. That's what an LLC is. I talk to folks a lot about that when there are rental real properties. So it can be a good tool to have. Switching kind of towards our last substantive topic, and those are the power of attorney documents. So we've got two different power of attorney documents. The first one is a durable power of attorney. This is a document that authorizes another person to make decisions for you for your property and your finances. It's a really important document because this is in effect while you are alive, and it is terminated when you die. So just because you have a will and have nominated a personal representative does not mean that person can act as your agent during your life, because the will only comes into effect when you die. So your agent under your durable power of attorney is that person who can function on your behalf with regard to your finances during your life. This document can be effective immediately upon when you sign it, or it can be effective only upon a finding of incapacity. Again, it just kind of depends on your circumstances, what works best for you. So benefits to having a power of attorney, of course, names a decision maker. And I think the most important thing to think about when nominating your agent is that it's someone you trust and someone who is going to look out for your best interest. A power of attorney can work to prevent conservatorships. We'll talk about that in a minute, but that's a court process where someone is appointed by the court to make financial decisions for someone else. And ideally, that's why we have a power of attorney, so we can avoid that court process. And of course, the power of attorney must be executed while a person has capacity and they can make that decision of nominating that person, right? And so I wouldn't recommend nominating your cat as your power of attorney agent, but I think, again, it's just important to think about who you trust to make those decisions for you. The other power of attorney document is a medical power of attorney, a healthcare power of attorney. And so we kind of separate these documents because different people might serve best in those different roles, right? The person you maybe want to make financial and property decisions for you isn't the same person you want to make your medical decisions. Or it is the same person, but it's helpful to have it in two documents so your healthcare providers don't have to deal with the financial piece and vice versa. So the healthcare power of attorney is a document that authorizes another person to make healthcare decisions as outlined in that document itself. Healthcare decisions can be a wide range of things, right? So it can include consent to treatment, refusal to consent to treatment, withdrawal of treatment, surgeries, procedures, things like that, right? About your healthcare. And again, just like with the financial power of attorney, it's valid during your lifetime and it terminates at death. Benefits to this, again, same as durable power of attorney, it names a decision maker, can prevent, that should be guardianship, that's the other process. And again, it must be executed while a person has capacity. We'll talk about this right now. In the healthcare power of attorney is a section called the living will, which is it lays out your medical directives for artificial treatment in the event that you are in a persistent vegetative state or you are in a condition that has been diagnosed as terminal, and anything else will only artificially prolong your life. So this form has some options for you to consider for what you would like for your medical treatment in the event you're at that point, where those decisions have to be made. I think this document takes a lot of stress off of family members and the people you have nominated to serve in this role, because then they don't have to make the decisions for you. You've laid your decisions out for them, and that takes a lot of stress off of a very emotional situation from my perspective. I think it's good for you to make those decisions about your care at a point when you've got the capacity to make that decision, right? And so the living will also provides an opportunity for you to think about other instructions regarding your care and your last illness, right? Who you want to visit you or who you want to have your agent share information with, comfort measures, food and hydration, whether or not that's artificial, and sometimes it can include funeral and burial instructions. On that note, I think typically your estate planning documents, like your will or your trust, don't always have funeral and burial instructions in them. In fact, that's something I don't usually counsel clients to include in those documents because they can change. But if you do have arrangements or prepaid cemetery plots or anything along those lines, or very specific desires, I think that's something that you should talk with your attorney about, because if you don't properly share that information, then maybe no one's going to know at the end of the day. And, you want to make sure that your wishes are carried out. With these documents, your power of attorney documents and your will and your trust, they are your confidential attorney-client privileged information. You aren't obligated to share this information with anyone, but I like to talk to people about the fact that if you do have those discussions with your family members, I think it better serves them, depending on the circumstances, to be prepared to know that they're going to be serving in this role for you. They don't have any involvement in signing off on these documents. They don't have to consent to you nominating them. But I think it goes a long way to have that discussion with whoever you're nominating as your agent and say, hey, are you comfortable with this? Do you have concerns? Maybe it opens the door to some discussions about what your desires really are, right? So I think that can go a long way, even though you're not obligated to share that information. If you don't have powers of attorney and you are in a situation where you are deemed incapacitated and you can't make your own legal decisions, the court has a process where someone is appointed to make those decisions for you. And this is called a guardianship or a conservatorship. A guardianship is the process to take care of you physically, to take care of your person, and to make healthcare decisions. And the conservatorship is a process to appoint someone to make financial decisions. We like to have powers of attorney because that's the best tool that we have to prevent guardianships and conservatorships. but it's not a guarantee, right? There may be some unique situation where a power of attorney is not accepted, or there's something wrong with it, or a whole host of other things that can happen where a guardianship and conservatorship court process is needed. It is an intensive process. The protected person is essentially stripped of their ability to make decisions for themselves because they can't, and they've been deemed legally incapacitated to do that. There are multiple parties involved in this process. So it can be really emotional. I have cases where people are contesting guardianships and conservatorships with their family members, and it's just like trust and estate litigation. It's just emotional. It's a difficult process. So again, I think it goes a long way to have those powers of attorney executed so that your wishes are known to the extent that they can be. Just briefly, estate tax, your wonderful CPAs at Silverbridge are going to be the experts on this. And so Idaho doesn't have an estate tax, but we do want to look at federal estate tax exemption, and it's pretty high for 2024. You can die owning $13.61 million without having to pay an estate tax. So if it's over that amount, then you are looking at your estate paying taxes. And so there's certain tools for spouses that we can incorporate into your estate plan if we're kind of in that range, with irrevocability and things like that. But again, fairly complicated, so I would not recommend a DIY estate plan for that case. But ultimately up to you. And then your gift exemption amount for 2024 is $18,000. So you can gift $18,000 without consequence. So final thoughts from me are, I think everyone needs some form of estate planning structure, whatever that is, however simple that is. It's to your benefit, and I think more importantly, to your family's benefit when you're gone, to have something in place, to have those very individualized desires laid out so someone doesn't have to make those decisions for you. And I think it is important to think through individuals you have nominated in fiduciary positions. That's your personal representative or your trustee or your guardian or conservator of minor children or your agent under either your financial or medical power of attorney. It's important that you are comfortable with those people acting on your behalf. And you can always change who those people are. You don't have to just nominate someone one time and then leave them in there forever. That's one of those things that you can look at when you do that health check of your estate plan every few years, because those relationships can change, right? Or maybe someone is not able to act in that type of role for you because they don't have the capacity to do so, or they've moved out of state, or they have their own things going on. You just never know, right? So really important to think through individuals you have in those positions. And my favorite, trusts are not magical unicorns. I know I've probably said that a few times today, but I hope that my clients walk out of our initial meeting knowing that they aren't obligated to create a trust. It might be right for you and it might be right for your circumstances, but they aren't right for everyone. So I think with that, if anyone has any questions, I'll turn it back over to Brittany and she can help me figure that out.
Yeah, will do. We do have a few that came into the chat. So,
Great.
On average, I don't know if you can even give an average, but on average, how long does a probate with a will? And now maybe I was under the impression trust did not do that either, but with a will, like how long does that generally take?
That's a really good question. So I think the quickest I see them is probably about 6 months. And that's just because in a probate, you do publish notice to creditors in the newspaper. And you have to let that run for 4 months so that creditors can come forward and say, I'm owed a bill or whatever from the estate. So in and out, your quickest day, I think, is 6 months. Typically, I see them at least about a year, but they can just sit on the court docket. There isn't anyone pushing them forward, and there's not usually any harm in having those just sit on the court docket until someone's ready to close it. Because oftentimes if someone dies and then someone has to sign off on taxes the next year, you want to sign off on those taxes for the decedent in the capacity of personal representative and not in your own individual capacity. So oftentimes I have estates just kind of sit open until the next tax season is done. And then sometimes with the trust, if you do end up doing a probate, same thing, but also sometimes with a trust, we recommend that notice to creditors is published as well, even though it's outside the probate process, just because, again, that kind of gives some confidence when funds are distributed that creditors out there are paid and taken care of. So that can take some time too, again, depending on the circumstances.
Okay. All right. Do you think a person who owns property out of the country would benefit from having a trust?
That's a really good question. I don't know the answer because you have to look at where the property is owned and that country's laws as well as ours. So that's a really tricky question. I don't know, but maybe.
Okay. And does your company, like, would you guys, your firm, I should say, deal with out of the United States issues like that, legal matters, or?
Yes and no. So we are licensed mostly in the state of Idaho. We've got a couple attorneys in Washington and California and Oregon. But with out of country matters, we would probably recommend to find an attorney in the country where the property is, because
Gotcha.
we're not going to be able, we could guess, and that might be really fun, but that wouldn't be really helpful. So
Yep, makes sense. Okay. Again, another like average type of a question, but is there like a base price with your firm on wills versus trust that you could provide, or does it really just vary?
It really varies, you guys, because I usually don't give people like a price estimate until I talk with them, because every situation is so different. Our firm, and I can't speak for every attorney, but most of us don't do flat fees. So we don't say, okay, pay us $5,000 to get a trust, right? Because sometimes that doesn't always work best for the client. And so we most of the time are just hourly. I like to say, trusts are on the lower, wills are on the lower side, and trusts are usually more complicated, but you can have a very simple trust as well and a very complicated will, just depending on the circumstances. So as much as I would love to give an average, it's so dependent on the situation.
Okay.
Yeah.
And I mean, kind of on that same note, is your firm taking new clients?
We are taking new clients. Yep. So we've actually got, I like to call us like an estate planning practice group at this point. So there's 4 of us partners. 1, 2, 3, 4. Yep. We handle the planning side of it, and then also the litigation side of things. And then we've got 2 associates who work in our estate planning practice as well. So yeah, we're well equipped.
Awesome.
Yeah.
Okay. Is a revocable trust the same as a living trust? And
Great
what are
question.
the differences?
That's a really good question. Yeah, they're pretty much the same. It's just a term of art and who you're talking to. I think it probably depends on what state you're in too. I use the terms interchangeably. Sometimes we just say it's a trust and you assume that it's a revocable or a living trust, but there's lots of different types of trusts, right? You've got trust for minors, you've got supplemental needs trusts, you have charitable trusts, you have irrevocable trusts, which can't be changed. So typically when someone says a trust, it's either a revocable or a living trust, which is the same. So
Okay.
it's another reason to love lawyers, because we do things like that.
Okay. And then, do you need a power of attorney specified if you have a trust, or is that just with a will?
No, you definitely should still have a power of attorney.
Totally separate. Okay.
Yep. Even if you have a trust, I still have folks do their power of attorney, and especially their medical power of attorney becomes even more important, because your trustee doesn't always have HIPAA authority and your medical power of attorney does, right? So that could be one of those things. If you have a trust, that's great. But if you haven't specified anyone as your healthcare agent, that could propel you into the guardianship and conservatorship court process. So yes, always have a power of attorney.
Okay.
Yeah.
And then, I mean, I kind of just thought of one. We fortunately haven't had to go, my husband and I haven't had to go through this yet. But when, how much does the lawyer like walk through the like process and steps with the, executors and such? Like,
great question.
We would be clueless, truly.
Yeah.
Like, and just what's the like?
I totally get that question. It's as much as you want us to. You don't have to have a lawyer for anything, really, at the end of the day. People go through probate process without a lawyer. Unfortunately, I see what happens when that happens, kind of on the back end, and we have to go back and fix some things. But, from my perspective, someone dies. You don't have to call me right away, because unless there's something on fire, you have more important things to deal with after someone's death, right? Than calling your lawyer.
Sure.
Maybe that's part of your process, though. That's totally fine. I always like to tell folks, it's okay. You can wait a few weeks, you can wait a couple months, you can wait a couple years, just try to get that in before the 3-year period. So,
Okay.
call me when you're comfortable. We talk about whether or not you need a probate. That's usually the first question. And then if you do, then we create all of the initial court documents. We review them with you, submit them to the court. And then my process is, once you're appointed as personal representative, then I kind of help you as you need me to help you, right? Let's say there's a piece of property that needs to be sold. You're not going to want to talk to me about that. You'll want to talk to your realtor about that, right? So, I can help you on the decision making with, do we sell the property, or do we need to get the property appraised, or is there an heir who wants to buy the property, right? That's kind of where I would come in. But like I said, I do a lot of work in probates at the beginning of the process, and then can kind of be quiet in the middle. And then towards the end, my advice is to have a hearing to close out the probate, because then that gives you the most protection as personal representative. Not everyone is of that mindset, but that's typically how we practice.
Okay. That's really helpful. Thank you.
I think that answered your question.
Yeah,
As much as you want,
it did.
as little as you want. Yeah.
Yeah. Thank you.
Yeah.
That was all the questions in the chat. So if anybody has anything further to ask, you can definitely unmute yourself and just go ahead and ask your question.
I've got my email and phone number up there as well, in case anyone, like I said, you're welcome to reach out to me separately.
Yeah, absolutely. Okay. Oh, wait. If you are an executor for several trusts, do I need an attorney also?
I would say probably, because as a trustee, so if you are the fiduciary over the trust, your term is trustee, you've got a fiduciary duty to the beneficiaries of those trusts, and you want to make sure that you are abiding by Idaho law as you are administering those trusts. That one can be, hey, here's everything I've done. Here's what I'm going to do. Will you just take a look and let me know if you see any red flags, right? Or it can be, I help you through the process step by step. It's just depending on the role and what you want. I think amounts of funds and assets that you're working with come into consideration for that question, right? If you're trustee over, $5,000, I don't have the same concerns, right, as I would if it was $5 million. And so I think that's really dependent on what assets you have there as well. But as a trustee, you do have a fiduciary duty. So you've got a legal obligation to the people you're administering the trust for.
Got it.
Yeah.
Okay. Well, as Megan said,
Cool.
if questions come up, feel free to reach out to her on your own through email or phone. And oh, there's one more. Okay, one
great.
second. Oh, probably used wrong title, but I guess this is the same part of the same question. Probably used wrong title, but the person that after death handles the distribution. Does that make sense?
So
okay.
Yep. I think the question is, who is that person? So if you have a will and you're appointed in the probate court, that's the personal representative. If it's over a trust, you're the trustee. And then if you're acting under a power of attorney, you're their agent. All of those people have a fiduciary duty. So you have a legal obligation in all of those roles.
Okay.
Okay.
Amazing. As you said, like not a super fun topic to talk about, but it's really important issues and things to consider. So we really thank you for your wealth of knowledge on this. And thank you everybody for joining us.
Thanks everyone. I really appreciate it. Thanks for letting me talk at you for a little bit.
Of course. All right. Thank you so much, Megan.
All right. Thanks everyone. Have a good day.
Bye.
Thank you for watching this summer speaker series. If you would like to tune in to future presentations or connect with this speaker or Silverbridge CPAs, please visit us online at silverbridgecpas.com.